You may begin.
Thank you, Erin. Welcome. We're excited to hear from you guys. My name is Darcy Kern. I'm a professor of history at Southern Connecticut State University and looking forward to this.
Good afternoon. My name is Jamie Gass. I'm director of the Center for School Reform at Pioneer Institute. It's a Boston-based think tank that does research on K-12 education reform.
Hello, my name is Tim Isaacs. I'm the executive director for the Center for Teaching the Rule of Law at Roanoke College in Salem, Virginia.
Could you guys please introduce yourselves and your teacher?
Good afternoon, judges. We are Unit 1. Our unit focuses on the philosophical and historical foundations of our government. My name is Georgia, and I will be studying political science at Middlebury College this fall.
Hello, I am Dylan. I'm an enlisted U.S. Army infantryman, and I will be in Fort Benning in July.
Hi, I'm Gigi, and I will be studying political science and English at the University of Connecticut next fall. But for now, we are all seniors at Trumbull High School, and this is our teacher, Ms. Boland. We thank you for being here with us today.
Great. So I'm going to go ahead and ask you the question. It's question 2, and then we will hear from you. So question 2. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? You may begin.
In Federalist 84, Hamilton asserts that a person's right to habeas corpus is perhaps of greater security to liberty and republicanism than anything in the Constitution. This ancient legal procedure ensures a prisoner's right to determine when they are being unlawfully detained.
A powerful and effective instrument against tyranny, the writ of habeas corpus is essential to limited government. The English barons first introduced the writ of habeas corpus in the Magna Carta of 1215, challenging the idea of the divine right.
Parliament enacted the Habeas Corpus Act of 1679 to ensure that the king released prisoners when the law did not justify confining them. This great writ guaranteed prisoners the right to invoke the protections of the judicial process, or, as Justice William Blackstone puts it, the protections of the Second Magna Carta.
During the colonial period, King George III resorted to unfair trials and a disastrous court system. The Continental Congress complained that the colonists were being denied their trial by jury and habeas protections only to receive the royal veto.
With this history in mind, the writ of habeas corpus permanently took root within Article 1, Section 9 of the Constitution, enforcing that the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. The clause is worded as a negative right with specific conditions, therefore protecting the people from governmental oppression and overreach.
The first statute passed by Congress was the Judiciary Act of 1789, which empowered all federal courts to grant writs of habeas corpus. Following the Civil War, the Habeas Corpus Act of 1867 allowed Congress to make the writ available to any persons restrained in his or her liberty, therefore extending it to formerly enslaved people and those convicted in state courts.
Post-World War II reforms expanded the writ through the incorporation process by which the Bill of Rights was applied to the states. Habeas corpus became a tool through which criminal defendants sought to uphold their civil rights against illegal state action.
In 1996, Congress further narrowed the writ through the passage of the Anti-Terrorism and Effective Death Penalty Act, which imposed time limits, making it more difficult to file for petition and limiting where habeas relief was available.
The Detainee Treatment Act of 2005 and the Military Commissions Act of 2006 further narrowed the scope of habeas relief by providing that prisoners held at Guantanamo Bay may not access the federal courts through habeas corpus. Instead, they must go through the military commissions and then seek appeal in the DC Circuit Court.
However, litigation would eventually unwind the previous tightening of habeas restriction. In the 2008 Boumediene v. Bush case, the Supreme Court held that the writ applied to alien detainees held at Guantanamo Bay.
And while habeas corpus primarily reinforces individual liberties, in times of severe threat to the public safety, this process does more to hinder liberty than support it, thus placing an unreasonable burden on the government and warranting for a suspension.
Just 15 days after the first shots were fired at Fort Sumter, President Lincoln unilaterally suspended the writ of habeas corpus to silence Confederate insurrections. Later, in 1871, President Grant suspended the writ in South Carolina, engaging in a war on terror against the Ku Klux Klan.
As Justice Blackstone illustrates this decision, the nation parts with its liberty for a while in order to preserve it forever.
The privileges of this great writ need to be balanced. American history has showcased the dual nature of habeas corpus, the essential role it plays in limiting government, but also the authoritarian potential it unlocks in suspension.
Thank you. We are now ready for your questions.
Yeah, you raise a lot of interesting points about wartime powers, parting with liberty, temporarily, severe threats to public security. I'm curious, what is the balance between the individual and the state in a time of war or rebellion? And who really decides when something is a rebellion that will justify suspension of habeas corpus?
To address that second part of your question, to have that balance, I think it's really important that the writ of habeas corpus and the ability to suspend it does not remain in the hands of the executive, as Lincoln had done so to unilaterally suspend it, but rather have Congress be that check on the power of the executive. Because we can see in the time when they were discussing the Burr conspiracy, President Jefferson wanted to suspend the writ of habeas corpus. But because there wasn't enough evidence, we see Congress going back and forth debating this, allowing for good dialogue to occur, and the bill ends up dying and habeas corpus is not suspended. So I think having that check on the executive is really important to ensure that habeas corpus is not being abused.
I would respectfully disagree with Gigi. I think there is a large difference between the suspension on a state level and on the federal level. For example, in our own Connecticut Constitution, in Section 12, it enumerates in the suspension clause that the right to suspend lies within the legislative branch. And this is completely distinct from what it says in our federal Constitution. And I think the reason why it doesn't say this in our Constitution is because it allows for this balance. And I think President Lincoln in this case was justified in doing this because it is so vague that it allows for that.
I would agree with Dylan. And I also think looking back in the case of Lincoln and an executive deciding when a suspension was warranted, we can look to Lincoln, who looked outside of his window and saw Confederate troops right just outside of the White House and coming into DC. And I think it's very important that Lincoln made this decision. And as he illustrates after the fact, were I just supposed to wait until Congress be called for them to make a decision? And if that was the case, Congress didn't pass legislation affirming his decision to suspend until 2 years later. So I think this decision has to be done in a very timely manner, which is why I think that it's almost messy to leave it up to such a big legislative branch and leave it up to Congress, because it could take years. And in that case, the war could have already been over by the time that they came to a decision.
According to the U.S. Constitution, as you mentioned, only Congress has the power to suspend the writ of habeas corpus. That is, the president does not have that independent authority. Then why Lincoln, Grant, and we've touched on already, FDR, George W. Bush, why were they permitted to do it?
Well, looking at the case of FDR, Executive Order 9066, he never formally suspended the writ of habeas corpus, but rather the terms of the executive order were so blanket that he was able to detain 120,000 individuals in these internment camps, 70,000 of these being American citizens. And so I would completely disagree. And I think that this completely goes against the suspension clause. And it set a dangerous precedent. The fact that a wartime president is able to detain their own citizens outside the criminal process. And we can see this leading to the Emergency Detention Act of 1950, and even the legislation passed in Guantanamo Bay, where they're going around the suspension clause, but are still essentially doing the same thing by denying people their right to habeas corpus.
I think we can look to James Madison in Federalist 45 when he argues that during times of war and danger, federal power is much more expansive and federal power becomes bigger and more encompassing. And I think it comes down to what we were talking about before with striking that balance between individual liberties and what encompasses a need for the common good. And I think that in times of war and danger, in times of rebellion, sometimes it's necessary, although I completely agree with Gigi that it goes around the Constitution and is blatantly unconstitutional. It goes around the suspension clause. I think sometimes that's necessary in securing the common good and ensuring the prosperity of our democracy.
I would agree with Georgia, and I think our founders actually looked to ancient Rome when in times of war and danger, they would appoint a dictator such as Cincinnatus to expediently resolve the issues of the state. And I think we see in our Constitution a reflection of that, and the reflection of our founders' education and really admiration for ancient Rome. And I think we've seen that this process really has been effective in our own Constitution.
Is it ever justified? I'm sorry. What are some other parts of the Constitution intended to protect people against arbitrary incarceration?
So I think the Fifth Amendment in the assurance of due process is a very important principle that allows people to be secure in their liberties and in their rights to due process. And I think that due process is completely related to habeas corpus. And in the case of due process, we see this come into play a lot in times of habeas suspension. We can look to Guantanamo Bay, and in that court case, Boumediene versus Bush, which asserts that prisoners held in Guantanamo Bay have the right to due process under the Fifth Amendment, not under the suspension clause. So I think that a lot of times the Fifth Amendment and that right to due process and the process of the law is a very important assurance that allows habeas corpus to even be a thing.
I would agree with Georgia, and I would also say that the Eighth Amendment banning cruel and unusual punishments, and all these rights in our Bill of Rights being incorporated, as we talked about in our speech, through the incorporation doctrine during the Warren Court, are very important in allowing for habeas corpus to essentially come alive, because now these individuals have more grounds to file for petitions, and they have the larger ability to make sure that their civil rights are not being denied. And I think that ability to check upon cruel and unusual punishments is very important, especially with people being on death row. And even during COVID today, there's the argument arising that being in prison where the infection rate is 5 times higher than the national infection rate, that could be grounds for a cruel and unusual punishment claim.
Anything else?
I think if you were to actually look again, what Georgia was saying in the Fifth, we can see the idea of double jeopardy. And I think this really comes into play with Guantanamo Bay because these cases are held in military courts, individuals are also subject to the civilian courts, which totally rules out the idea of double jeopardy. So I think with the detentions at Guantanamo Bay, it's extremely problematic because it totally goes around the idea of double jeopardy because it subjects people to not only military courts, but also civilian courts.
Okay, thank you.
I'll throw you a curveball since you mentioned Rome and the dictator. Part of the problem with Caesar was that he made himself dictator for life at the head of a military. Is there a possibility that the American executive could use military commissions to sort of permanently violate a right of habeas corpus and seize power for himself or herself?
Well, in certain suspensions of the writ of habeas corpus, we see this idea of a sunset clause. The idea that the clause would sort of wrap up its legal presumptions and for example, during the Civil War, the Confederate President Jefferson Davis actually incorporated this idea of the sunset clause, even though he was on the Confederate side. And we saw that he had to keep, I'm sorry, may I please continue my thought?
Yes.
We saw that he was able to keep adding different suspensions because the sunset clause kept running out. So this sunset clause is really an example of this check on power.
That was good. that was really good. You guys know your stuff. Yeah, this was, you have clearly thought very deeply about both the philosophical background to this and the practical application of this at the state and the federal level, the relationship between the two. You mentioned the Burr conspiracy. One of you mentioned that, the sunset clause, Rome in the position of the dictator. You mentioned the Connecticut Constitution, which I thought was really good. You know your own state constitution. And I liked how you tied it all one of you mentioned the balance between the individual and the common good. And I think it's a difficult balance to maintain. And I think that's something that we're learning as we go. But this was just an absolute pleasure to listen to.
Yeah, I'd like to first of all congratulate you on all your hard work and your hard work of your teacher too. You did an excellent job, certainly among the best, perhaps the best we've seen on this topic, which is a very difficult subject. It's a difficult question. I thought that you hit all of the kind of the main points that you needed to and covered a lot of historical. I was really impressed by both in the introductory portion and the Q&A, how you marshaled very easily not only historical evidence to make your arguments, but you also have thought a lot about it too. I liked what you said in the closing portion, line or so of your introductory remarks about the dual nature of these things. So you're not, and you had some disagreement with each other, and I think that is both healthy and really productive. I echo what Darcy said in terms of referencing the Burr conspiracy. That's a level of detail. Frankly, there's actually a UConn law professor, Kent Neumeyer, wrote a great book on the Burr conspiracy. But that was excellent. I thought that you're referencing the dictatorial powers of Cincinnatus. So certainly he had an enormous influence on the founders and Washington in particular. You did an excellent job. You should be really happy with your performance this afternoon.
Tim, you're muted.
I'm not sure what else I can add that my colleagues haven't already covered. You answered my question as I would have expected. You may want to also consider the Sixth Amendment, speedy trial, the Burr conspiracy. I think that the one thing that you did and did really well, and I don't know that it was intentional, but it was there, you gave voice to the tension that exists between habeas corpus and what it seeks to protect and what the alternatives are without it. And in fact, Darcy made this comment about the struggle to finding the balance between the individual and the common good. And one of the questions that I was going to ask was, is there ever a time when individual rights take precedence over the common good? And you really got to the heart of that tension in a way no other group has. So thank you very much for a very enjoyable presentation.
Thank you so much.
And good luck the
Thank you
rest of the
so
day.
much, judges. Thank you.
Thank you.